Greeting everyone. My name is Diraj Maharjan and I'm representing Group 18. And this is the presentation on contract and corporate law. My group members are Priyas Lamsal, Jibraj KC, Bikash Hamal, and Sudin Bhattarai. So talking about contract law, Australian law is concerned with enforcement of promise that are legally binding in terms of contract. There are 6 essential obligatory elements for a relationship to be considered as a contract. First is offer, second is consideration, then comes written instrument, then capacity, intention, and lastly, acceptance. The precedent case of frustration. In this presentation, I have examined some cases that demonstrate the application of law of contract by frustration. The case of Scullens New Limited versus Tuhis Limited. After a close examination of the contract frustration, the case demonstrates that when frustration event occurs but have been provided for in the contract, the terms of contract holds. Now I would like to call Priyas Lamsal for further presentation. Thank you.
Thank you, Diraj. Hello everyone, my name is Priyas Lamsal. Now I'm going to present the further presentation. 40 versus Metro Publishers. The common law does not advocate for purposes of contracts. In most cases, contract ends when their intentions are fulfilled, work is complete, and payment is made to that effect. Nevertheless, contract may be terminated for other reasons aside from the completion of the contract, such as contracts terminations by frustration, terminations by agreement, terminations for reputations, and terminations due to a breach. However, there are guidelines and thresholds that must be met and ascertained within the parameters of law for such terminations to be valid. The case of Scullens New Neons Limited versus Tuhis Limited. The case can be perfect precedent case in this context. The neon company's primary business was the erection of and serving of neon light for the purpose of advertisement. They entered into a contract with Tuhis Hotel and erected neon sign on several of the Tuhis Hotel. During the war, when the contracts were still valid and binding, the government of South Wales imposed regulations that prohibited the erections of neon sign. Tuhis sued the company and the judges examined that the contracts for frustration. The judges decided that no frustrations had occurred on the contract, thereby compelling the company to pay their rents. The aspect of capacity. Contractual capacity entails the ability of a party to enter into a contract. It deters minor, drunkard, and mental impaired from entering into contract and agreement. As for sound person, they can make decisions founded on true assessment and scientific evidence. In our case, Boswell, Pickwick, Havoc Films, and Metro Publishers all have offer and means of persuasions to lure forthly into a deal. The contract is binding when the parties agree. In this case, however, Fortley signed the contract, but he recalled it before it could be dispatched when rendered it void. Thank you. Now I'd like to call Bikash for the further presentation.
Thank you, Priyas. Hi, I'm Bikash Hamal, and I'd like to continue our presentation from Part B of Business Corporation Law. Let's go to the introduction first. Businesses go through life cycle that runs from the time of conception to dissolution or insolvency. Corporate law is concerned with governing the conduct and relations of persons, companies, business, and organizations. The main focus is to streamline and promote smooth operations of businesses. The Corporation Act 2001 was created to regulate and monitor the standards of conduct of company directors and their internal processes of the company. The conduct of the company directors face repercussions of public law when they breach their code. Now, the corporate law interpretations. The corporate law demonstrates the company directors have the duties and responsibilities to the corporation. One of these laws is that the company directors should act within their powers. The powers of the directors are intertwined in the company's article of association and other relevant agreements and resolutions. Another duty of the directors is to exercise reasonable care, skill, and diligence when acting on behalf of the company. Diligence calls for them to consult before arriving at a decision and implementation. I would like to end my part here, and further will be continued by my friend. Thank you.
Thank you, Bikash, Hamal. Hi everyone, I am Jibraj KC, and I am going to present our presentation on Mercedes legal position. The aspect of diligence points that the directors should consider the decision they make before implementing them. In this case, Mercedes is guilty negligence of duty because of the following point. She overlooked her duty as a director and did not follow due to diligence when making her decision. She did not inspect the new premises for the relocation of company's branch. She was also reluctant of conducting the reconnaissance and feasibility study of the venue. This context indicates the Mercedes can be sued for negligence of duty. Uh, and here another topic goes on Mercedes and Felix. Mercedes did not conduct a reconnaissance and also a feasibility study of the venue. This amounts to negligence of the study. Felix, on the other hand, was reckless and instead of conducting a better feasibility study, he decided to see and settle on own. This means that Mercedes can sue or be sued by Felix. Thank you, and I would like to call my friend Sudin Bhattarai for continuing our presentation.
Thank you, Jibraj KC. And the next topic is the implications of the above actions according to the law. According to Section 182 of the Corporation Act 2001, the decision by Mercedes is not protected by the law. Her decision could only be supported if she consulted her directors before making this decision. She would also be liable for breaking 588G of the Corporations Act 2001. It is evident that she did not take any attempts to stop the company from reallocation to the new premises. And moving forward, Greg's legal position with respect to breach and insolvency. Greg's and Mercedes have the same fate. He assumes the role of a director and he only met the minimum threshold for such a position. He cannot use ignorance and illiteracy as defense in the court of law. He also did not stop the company from being insolvent. Greg's seconded Felix in reallocating the warehouse without security. Thank you, our professor, for giving us such a lovely opportunity to present ourselves. Thank you.